Good afternoon, colleagues. Thank you very much for members of staff who have taken the time to attend this information session with respect to POPIA. This is a really, really important matter. It affects the university in fundamental ways, and it will affect each and every one of us as we work through the process of being aligned to the legislation that imposes a number of obligations on all. You are aware that the legislation will in fact take effect. It's just a few weeks away. And as a public university, we hold extensive records that contain personal information. This includes information that relates to student data, information that relates to staff data, and very importantly, research data as well. We work from a premise that privacy is a constitutional value, but this has to be balanced with the right to information, which is also provided for in the constitution of our country. Our task as a university is to insert the POPIA safeguards into all we do in processing the data that we have, data that we hold, and we should be understanding POPIA as a privacy program. And this is, so what we are busy with at the moment is not strictly speaking a project that has a start date and an end date, but we like to think about it as a program because it will be ongoing. So compliance with the legislation is of course a requirement, and similarly there are serious consequences for not being compliant, and there will need to be significant capacity development because POPIA compliance is the responsibility of all of us. Anybody who does anything with personal information that your work role requirements give you access to, we will all have a responsibility with respect to POPIA compliance. We have been working on the development of an implementation framework. This has been a necessary step on the POPIA implementation journey, but we will not arrive at the point where we can say that we are now compliant. And there will not be such a thing as a compliance certificate. That's just not possible, not for ourselves, not for any other organization, because of the nature of what it is that we are busy with. But we do it's certainly embedded in how we work with personal information. Assisting UCT in this process of implementing a POPIA program are colleagues from Novation, an external entity, and they specialize in information law. And our colleague Elizabeth de Stadler is from Novation. There are a few other colleagues from Novation who are also present in this meeting. And the intention is, and the purpose is, to have Elizabeth address us on some of the key issues that we should be aware of and we should take on board. And of course, we certainly have appreciated some of the questions that have already come in preparation for this meeting, and also have come in previously on the popia@uct.ac.za to that particular account. We encourage colleagues to continue to do that. We will make every effort as best possible to respond to the questions for which we are able to provide answers. Those for which answers at this particular point may not be possible given where we are in this journey, we'll take those on board and we will build a question and answer tool that will be a living tool as we constantly deepen our understanding of what is required, and also as we come up with suggestions in terms of how to deal with the various scenarios that will face us. So we are on a journey, all of us, and it is imposing obligations on each and every one of us. But it's a journey that we will only successfully complete with the input, with the engagement, and with the support of all of our colleagues. So Elizabeth, over to you. Thank you.
And thank you for those of you who've persevered with us. The start of this meeting is actually a fairly good metaphor for how POPIA has been introduced to South Africa. So I'm going to start off today just with a blistering overview of where we are now and where we started, and then just talk about some POPIA basics to make sure that everybody understands the scope of the legislation, but also very importantly to dispel some myths that have been created over the last number of years. And then lastly, we very much want to get to your questions. Quite a few questions have been submitted via the very important POPIA at uct.ac.za, and we are going to encourage you after this meeting, during this meeting, to continue to submit those questions whenever they come up. And then obviously also you're welcome to submit questions via the question and answer feature on Teams. Right, so where are we as of today with POPI? Very helpfully or unhelpfully, depending on your philosophical bend, the information regulator has created this doomsday clock, which is on their website. And it counts down to the effective date, or the anniversary to be exact, of the effective date of the 1st of July 2021. And according to the screenshot which I took this morning, we have roughly 24 days to go. Right, so POPI has been a very long time coming. The legislation in its current form was already drafted in 2009. And then it took government quite some time to enact it. So it was enacted in 2013. Then in 2016, the current chair and part-time members of the information regulator were appointed. And then February last year, or actually it was a bit later than that, in May last year during the lockdown, the president announced the effective date, which was 30 June 2020. And then what the legislation said is that organizations have a year to bring their processing activities into compliance with the Act. So that's where we are now. There is this deadline looming of the 1st of July. But actually, as a sector, higher education has been working on its response to POPI for a very long time, and UCT has been very active in those endeavors. And there are two that I want to highlight before we go into our quick recap of the POPI basics. So the first is that there is a USAF-driven guideline to how POPI functions within the higher education industry. It is a very useful document. It is basically an application of POPI to the typical sort of activities that we find at universities. And this document took the better part of 3 years to develop. Currently, the document's not going to be formally accredited with the information regulator, but there are other codes of conduct that are in the formal accreditation process that will be relevant. And that brings me very rapidly to the second sort of sector-wide initiative that I want to bring to your attention, and that is a code of conduct that has been sponsored by ASAF. But before I do that, maybe just the last word on the USAF guideline. It will remain a guideline for now, so think of it, if you will, as a source of best practices for universities when it comes to implementing the Protection of Personal Information Act. Then ASAF has been working on a code of conduct which currently the intention is to accredit. And once a code becomes accredited, it essentially gets the status of the same status as POPI. It becomes enforceable, and this code covers research activities. There have been position papers that have been published about the ASAF code, and that code is in the process of being drafted. So, while we know for certain that the legislation comes into full force and effect on the 1st of July, there are things that are still up in the air, and I want to echo something that the registrar said during his introduction, which was that POPI compliance is not a once-off task. It's not a list of things that we have to do and then we are POPI compliant. It's also not something that is a short-term initiative or a project. It has to become part of the way in which the university works with personal information. It has to become ingrained in how we do our jobs. And that, by its very definition, is a longer-term endeavor and something that is cyclical. It never really stops. And that is how principle-based legislation works in general. So for those of you who are wondering, is this unusual? Doesn't other legislation work differently? The answer is yes and no. You get rules-based legislation that gives you a set of rules and you must follow them, and it's very binary. You're either compliant or you're not. POPI is an example of principle-based legislation. We borrowed it from the European Union, from the Data Protection Directive, which was enforced in the European Union since 2002 and has fairly recently been replaced by the General Data Protection Regulation. And it is very, very consistent with international best practice in that it's principle-based, which means that it's not something that is easy to implement. You have to embed it into what we often refer to as processing activities. Also, standard operating procedures is another way to think about it. So what I hope to do with a bit of time that we have today is to start explaining how we will achieve that, but then also more importantly to answer your immediate questions. Right, so just very quickly, the legislation that we are referring to today is the Protection of Personal Information Act, and in order to understand it, there are certain fundamental concepts that are very important. The first one is, what is personal information? Now, the definition in POPIA of personal information is incredibly broad and purposefully so. It includes any information that you can relate back to a living individual or an existing organization. So POPIA is very unusual and broader than most pieces of data privacy or data protection regulation, in that it also protects the privacy of entities or organizations. There are only 2 countries in the world that does this. Right. So it's any information that I can relate to an individual or an organization. And from the definition in POPIA, we can glean certain examples. So the sort of crown jewels of personal information are so-called identifiers. Those are pieces of personal information that can be used to identify an individual or organization. The most common example of that would be your ID number, but there are other numbers that get assigned to us at universities that are also identifiers. So a student number or a staff ID or staff number would also be examples of identifiers. Then you get other types of identifiers that are biometric. So that is when we use physical attributes to uniquely identify an individual. Usually, companies do not have biometrics because they do not have a physical body. And biometric information spans the gamut from the ones that have been around for many, many years, so fingerprints, for instance, to things that are fairly new and evolving. The hot topic has been for a very long time facial recognition, but that is now being replaced by new technologies such as voice recognition and even things that are quite creepy, like smell recognition. So biometrics is where new types of personal information is being discovered all the time. Then there are the more demographic kind of information that we have about people, which includes your race, what language you speak, your ethnicity, your gender. And then we also have background information. So that can be anything from your financial background to your educational history. What I find useful to think about there is anything that you would put on your CV constitutes personal information, right? Then there is the information that is becoming very, very important and is used these days not just to record history, but also to shape it. So when we talk about information about your preferences, your opinions, your likes, your dislikes, your behavioral information, where you go, who you see when you go there. These are the types of information that is being used in a lot of new technologies that can increasingly start becoming quite grey from an ethical point of view as well, and was the subject of, or has been the subject of, many films like The Social Dilemma or The Great Hack. If you want a quick tutorial in the intersection between POPIA and ethics, The Social Dilemma and The Great Hack are 2 great documentaries to watch. And essentially, these are the types of information that POPIA wants to regulate. Right? So just because something is personal information does not mean that we can't process it. Quite the opposite. So POPIA does not really tell us when we can't process information. It rather tells us the circumstances that have to be present under which we can process personal information. Right? So very broad application, this legislation. Another way to look at it would be to think about whose personal information a university such as UCT uses in its day-to-day operations. So I've taken a stab at defining what is referred to in the legislation as the data subjects. Very strange phrase, doesn't fall easy on the ear. But it's important because it tells us who will be impacted at the university by this legislation, and the answer is almost everybody. Here is a list of the typical data subjects. So when we talk about student personal information, that is a very important sort of category of data subject at the university, and we can't just think about the registered students. It starts already when a student just indicates that they are interested in coming to UCT. All the way through the application and admissions and registration processes to the point where the student is actually at UCT, and then even after our sort of formal relationship with the student ends, or our relationship with them as a student and they become an alumnus, POPI will still prescribe rules for what we can and can't do with alumni information, for instance. So it's the entire life cycle of a student, if we were to put it like that. And the same goes for employees. So we've got incredibly sensitive information about our staff. And again, that the processing of that information already starts when someone just applies for a position at UCT. So there are also categories of data subjects that might have applied but weren't ultimately successful. We still are responsible for their personal information. And then once again, once the person leaves the employ of UCT, we have to protect that information and process it in accordance with this legislation. The registrar mentioned researchers and research participants' personal information, and that is the sort of category of data subject or a category of processing that will probably be impacted by the ASAF code for research in terms of POPI. What I do want to say is that POPI, and I'm going to talk about it in a moment in a bit more detail, takes a very balanced view when it comes to research activities. So I would say that POPI actually does a fairly good job of balancing the right to privacy with the public interest in research activities and the importance of research. So there are some very crucial exceptions that apply when it comes to research activities that does limit the impact of the Act on research somewhat, but we can't talk down the fact that POPI will have a significant impact on how we manage research data, both of participants, but also of the researchers themselves. Then because POPI also applies to organizations, we have to think about the personal information that we gather and use of what I call affiliated organizations. This might be donors, funders, subsidiaries or units or centers or companies in which the university is a stakeholder, partners, so when we are in exchange programs, and then service providers, suppliers and independent contractors, they also have personal information and we must process it in accordance with the principles in the legislation. And then lastly, there are always other individuals who don't fit comfortably in any of these other categories, such as family members of students and employees or beneficiaries, if we think of us of the employment context, and perhaps, you know, when you have insurance, you know, your beneficiaries will be information that the university needs. Sureties and emergency contacts and even visitors and members of the public have personal information, and when we gather it and use it, we must follow the principles of POPI. Then another very important concept in POPI is this concept of processing. And a lot of the misconceptions about POPI stems from a misunderstanding of what it means to process personal information. So if we make the bold statement that POPI will regulate all processing of personal information that happens within South Africa, what does processing mean? And it can be both active or passive, right? So processing usually looks something like the light blue block there in the middle. Information has a life cycle, and processing usually takes the form of a process or procedure that starts with planning, and we collect and create personal information right through the life cycle to the end where we decide to retain some information or destroy the rest. And processing activities really lie at the heart of POPI. When you want to become POPI compliant, also that is what you will be assessing, is you will look at certain processes in which personal information is created, collected, used, shared, transformed, stored or destroyed. And so what comes to mind immediately are processes like the application process. So that is our primary vehicle through which we get information about our students initially. And then there are many other processes that either collect or generate personal information about students. Similarly, when a person applies for employment, there is a process that is followed, the sort of application process for employment. When a person is successful in their application for employment, there is a process that could probably loosely be described as the onboarding process. In other words, where a person becomes an employee and can start performing their duties. These are all processes that we have to bring into compliance with the legislation. So in order to do that, we start off with some policy development. And the good news is that UCT did not need to start from scratch. There are already several policies that already, in a way, have implemented the principles of POPI in certain contexts. So for instance, there is an information security policy that was already approved last year. There is a records management policy that although we are currently reviewing it, has been in place for many, many years. Similarly, research policies do not need to be created from scratch. We are simply realigning them. The sort of one policy that will be created, and there is already a draft, is the data privacy policy. Right. So in a moment, I'm going to, in 5 minutes, break down the principles in POPI, but essentially POPI prescribes certain principles. Some of them is about privacy. Privacy is about what personal information are we allowed to have and what can we use it for. And then there's information security management, which sets out the principles for the information that we have control over. What are the things that we have to do to ensure that we protect it against failures of confidentiality, integrity, or availability. And then lastly, there's records management, which dictates what information do we keep as evidence of our relationship with a student, a staff member, a research participant, or any other data subject. We don't keep everything, but there are some records that universities have to keep indefinitely, and POPI allows for that. Right, so if we break it down just a little bit more, and in about 5 minutes, we're going to get to your questions. If we break it down a little bit more, at its core, POPI is about balance. It's a balancing exercise between what seems often to be competing interests. And for those of you who have a legal background, you will immediately recognize this is sort of the typical balancing exercise that we have to perform whenever we are talking about constitutional rights like privacy, is that there are competing rights. So the right to privacy, for instance, competes with the right to freedom of expression. So on the one hand, we have the constitutional right to privacy, which includes the protection against unlawful collection, retention, dissemination, and the use of personal information. And this comes from the preamble of the legislation. And then on the other hand, we have business concerns. And by that, I mean the need for public and private bodies to achieve their objectives in an effective and efficient way. And POPI recognizes this as a legitimate reason why personal information is being processed. So again, there is this concept, this sort of misconception about the fact that POPI will inhibit the processing of personal information, whereas it actually in some ways encourages the use of personal information as long as it's done in accordance with the principles set out in the legislation. So it really is about a balancing act. And for those of you who are ethicists, you will also recognize this balancing act. And so the good news is largely if you behave ethically with personal information, you will also be compliant with POPI. Those principles are very closely aligned. And so for a great many people at the university won't be completely foreign. So if we just think about very briefly the topics that the legislation covers, I've already spoken a little bit about information security management. Those are these outside layers. So no matter where you are in your processing activity, you have to constantly think about information security. And what that is about is thinking in terms of who needs to have access to it. So confidentiality or access control. You have to think about the integrity of the information. Is the information that I'm looking at, is it valid? Is it fit for purpose? Is it, sometimes even we talk about, is it correct? So how do we protect the integrity of that information? When there is a data breach, my first question is always, what did they get access to? My second question is, can you tell whether there have been any changes made to the information? If I were to ever hack a bank, for instance, I'm not going to do it so that I can look at my bank balance. I'm going to do it so that I can change it. And so what are the mechanisms that a bank have in place to know that the integrity of the bank balance has been preserved? Every year we have 1 or 2 universities that have similar breaches where students try and access marks. And again, they don't do it to look at the marks, they do it to change the marks. And then lastly, we have to be concerned with the continual availability of the information that we need to perform our functions. So this is also a bit about business continuity management, which is a topic that was front of mind, for the last while, not just at UCT, but across the world, as we had to figure out how to quite quickly work remotely with information. So do we have measures in place that ensures that the information is available when we need it? Then when we get to the inside there are assessments that are required when we plan to use personal information for some new purpose, and we're constantly innovating at the university. So what POPI will prescribe is when we want to do something new, particularly if it is something innovative or original with personal information, we have to do personal information impact assessments. And this is generally seen as a positive because it reinforces all kinds of other handy design principles, and generally speaking, what the research shows us is that it enables innovation rather than stopping it. When we collect or create personal information, we have to apply a principle that the shorthand that I use for it is the less is more principle. We must stop over collecting personal information. So for instance, we shouldn't collect personal information that we don't use, and you will be surprised how often that is still the case. We also shouldn't collect information over and over again if we already have it. So this encourages things like records management and master data management so that we make sure that we're not recollecting information. This also is very handy in the sense that it encourages efficiency. When we collect the information, we must also make sure that data subjects understand what the information will be used for. So transparency is a cornerstone of the legislation. That we summarize as the rule of thumb that there should be no surprises. A person should never feel shocked or surprised at what their personal information is being used for. When we use information, we also often use it in conjunction with other organizations. So we might, for many various reasons, share personal information between organizations. And that is allowed, but we have to do it only under strictly controlled circumstances. And 9 times out of 10, there should be a contract in place that ensures the continued protection of that information. When we take information that we already have and we think of new things to do with it, again, we need to check that what we're doing complies with the principles of POPI, and that is done through what is sometimes called a further processing assessment. So again, just checking and getting advice before we do something new with personal information will be the new order of the day from the 1st of July. And then lastly, we have to think about once our relationship with the research participant or with the student or with the employee has run its course, what is the information that we have to store or retain? That might be for legal reasons or for operational reasons, and POPI says that you can keep information if you've got good reason to do so. And then lastly, we have to think about, okay, that information that we don't need to keep, how are we going to destroy it? There are principles in place to ensure that we do that safely, that we don't, through our destruction processes, inadvertently disclose information, or to breach confidentiality. Right, so there are a couple of myths that I want to get to, and then we will get to your questions. So the first myth, and this is very important, is that even if information is public, so it is found in a public record, or it is found on the internet, and is accessible to everybody, just because it's public doesn't mean that POPI doesn't apply to it. So POPI applies to public information as well as information that is private, in other words, that isn't available to everybody. Right? So even if information is already available on the internet or in a public record, it doesn't mean that we can do whatever we like with it. Most of the principles in POPI will apply to it equally, just as if it was private information. So a way to think about it is personal information can either be private or public, and POPI will still apply to it. And we can probably have a whole session just about the philosophical reasons for why this is the case, but it is not unusual. This is something that is recognized in all data protection regulation, is that even harvesting information from public sources doesn't absolve you from responsibility and to apply the principles of data privacy and data protection. Then the other misconception that we find at the moment is that a lot of people just think, well, I just need consent and then I can do whatever I like with personal information. Consent should actually always be the last resort. Probably about 80 to 90% of the processing that happens sort of on the administrative side at the university is either done because we have a contract with the person. So the student contract authorizes us to do the lion's share of the processing that we do of student information. So anything that we do with student information that is necessary for either for concluding the contract with the student, or is necessary for performing that contract. A student pays us and we provide them with a world-class education in exchange. Anything that we do with personal information that is necessary to achieve that will, as a rule, be lawful. Okay. The other big driver for the processing of personal information is other pieces of legislation. So the Higher Education Act, for instance, or other pieces of legislation might prescribe how we process personal information. So when we talk about the information of service providers, for instance, tax legislation mandates, what a lot of the personal information that we have to process. And so that will also be almost automatically lawful in terms of POPIA, and there's no need for consent. Where consent does become important is obviously in the research context, and a big topic within the ASAF Code of Conduct is what does a POPIA compliant research consent look like, and that will crystallize in time. The third misconception is if we get breached, we are going to get a fine, or the Vice Chancellor is going to go to jail, and that is not how the enforcement of POPIA works. So if there is a data breach or a complaint, or the information regulator decides on its own to investigate UCT for an infringement of the right to privacy, or then what will happen is an investigation, which may or may not culminate in something that is called an enforcement notice, and only if we disregard or ignore the enforcement notice do fines and things like that come on the table. And that's not to say that cases of non-compliance won't be harmful to the university. It's not just a fine that we have to worry about. Data breaches usually lead to quite unpleasant media coverage, and can harm the university's reputation. There's also disruption and costs that are associated with dealing with non-compliance that we have to that we have to take into account. So it's really important that we get this right, but it's not the fine that makes POPIA important. Rather, it is the information regulator's ability to change the way in which we process information overnight, which can cause a lot of headaches. The other misconception is that POPIA only applies to information that we collect after the 1st of July, and that is also not true. Any information that we have and are processing, even if that processing only involves the storage of the information, will be subject to POPIA come the 1st of July. So even historical or legacy information will be subject to the legislation. And then lastly, and we're seeing a lot of questions coming through the POPIA at uct.ac.za website, email address, and that is that people are asking us for a POPIA compliance certificate. There is no such thing. The information regulator actually emphasized that publicly last week, and that is because there's no such thing as 100% POPIA compliance. At best, we are all going to be trying to be compliant as best we can to a satisfactory level, and that is going to continue indefinitely. So there is no such a thing as a formal POPIA compliance certificate. There are, however, and the regulator called them snake oil salesmen, who are selling POPIA compliance certificates. All that tells me personally is that they don't understand POPIA, but that is underlines something that is really important, and that is for the foreseeable future. We will also have to educate people around the university, not just within the university, on what POPIA is and is not about. So this is in no small part why we are having these sessions. It is the start of talking about POPIA roles and responsibilities. Although today I expect we're going to be very much focused on what does POPIA say and not say, it is important just to talk about the roles and responsibilities that are created by the legislation and how that filters down to pretty much everybody who is associated with the organization. So a lot of the times people think POPIA is only the responsibility of the information officer and the deputy information officers. Your information officer by law is the Vice Chancellor. The deputy information officers are still being appointed. And there will be an announcement in due course about who they are. They will be supported by what we are currently referring to as POPIA compliance officers, a team of people who are tasked with advising the university on how to become compliant. But we always say POPIA is a people problem. There are responsibilities that will filter all the way down to people who use personal information as part of their daily job at UCT. And so it's important that we understand that POPIA compliance is dependent on the behavior of everybody at the university. So here are just some of the roles and responsibilities. The information officer, as I said, is the vice chancellor, and that role can't be delegated. That's how serious POPIA is viewed, is that it will always be the head of the organization in public bodies that will be tasked with ultimate accountability for POPIA compliance, and then they are supported by deputy information officers, which will be the registrar and some others that will still be announced, and they do the work of becoming POPIA compliant on behalf of the information officer, but they only monitor and advise and report on the level of compliance. Ultimately, as with any policy or any piece of legislation, it is down to the organization itself to ensure that the different areas of responsibility is brought in line with the legislation, and so there is a lot of responsibility that will also befall directors and deans, and over time we will be communicating exactly what those roles entail. But what I want to get to is the role of everybody. So in the first place, at this stage in POPIA compliance, or the journey that the registrar referred to, what we expect of employees and what we are going to try and inspire is that we spread the word about the handling of personal information. What we want to instill at this point is that where you are uncertain, you should reach out for advice on if you feel at all uncertain. That is usually a sign that there might be something amiss, and you mustn't hesitate to ask for some advice. A lot of this is behavioral, and so the only way to learn, I think, is through questions. We also need everybody to be on the lookout for incidents. So where information was disclosed, whether it's accidentally or whether there has been malicious activity, the university will be largely dependent on employees and students to alert it to these instances. And it's very important that we manage those incidents, and then also that you take part in training as and when it is rolled out over the next months and years, to ensure that we stay up to date with what the best practices are and what the policies mean in particular situations. Okay, so that concludes, and I realize we did this at a breakneck speed due to our technical difficulties initially, but it won't be the last time that we talk about these, and there will be many communication opportunities and training opportunities in the months and years to follow. But this is just intended as a start. There have been some questions that were submitted to us ahead of time, and I'm going to start attending to some of those. I just want to reiterate that even those questions that we don't get to, we do intend to start creating this living frequently asked questions resource so that we can continue to answer your questions and that everybody can benefit from both the questions and the answers. So I'm going to start with the ones that were submitted ahead of time. If we can't answer a question now, we will do that in follow-up communications. Okay, I'm just going to stop sharing so I can get to my list. There we go. All right. So there were many questions that were submitted about requests for information sessions, and I want to encourage everybody else who have not submitted these requests to do so. We will consider them and get back to you on specific interventions in your areas, but certainly where people feel at the moment that they want to know more about POPIA, we encourage that, and we will try and schedule sessions and answer questions in those areas as well. So please do keep on asking for these information sessions. The second question, I'm going to read it verbatim, was, as a supervisor who had to sign off on my students' MOU, I had access to their date of birth and ID the date of birth and ID information of anyone at UCT. Why is this not a violation of privacy? Okay, so I'm going to extrapolate the principle, but from now knowing that our IT colleagues will indeed investigate whether it should be the case that everybody's got access to all of the ID numbers. So how POPIA works is we have to think in terms of internal access. Again, the principle is less is more. So only people who need access to specific personal information to perform their function must have access to that information. So what POPI does inspire is a sort of lockdown, if you will, of personal information to only make it visible to those internal staff members who need those pieces of personal information to perform their duty. And this is often referred to as roles-based access. And again, less is more. So it's not that POPI says you can't have access to dates of birth and ID numbers. In fact, great many people at UCT will need access to the dates of birth and ID numbers of pretty much everybody, all students, all staff. But it is about defining who those people are who need access to it and then giving them the appropriate level of access. Then we've had a couple of questions around requests for a POPI compliance certificate or a statement on UCT's stance on POPI. We are currently working on a sort of placeholder statement and on standard responses to these requests, because we are getting quite a few of them. The answer in most instances are going to be, it depends on the context, right? So when you send email, and again, the POPI at uct.ac.za email address is the appropriate place to send it to. We will provide you with advice on how to respond, but our first response to you is always going to be, please give us a bit of context around who the person is who's requesting the statement and what information we are sharing with them, because the reason why personal information is being shared, processed, stored, used is always going to determine the answer. And that is the hallmark of principle-based legislation, is that the context is king. The context determines what the appropriate response will be. So if you do get a request for a POPI undertaking or a POPI compliance certificate, please do send it to us and we will advise you as to the appropriate response. Then there was an inquiry as to who the information officer is for UCT. As I said, that is the Vice Chancellor, and that is how it's going to stay, because the legislation does not actually allow for a public body to authorize someone else to be the information officer, and I think that is an indication of how serious POPI compliance should be taken at public and private bodies for that matter, but it is the VC. Then there has been requests for support or legal expertise on fulfilling GDPR and POPI compliance in agreements and contracts, and this happens both in the research context as well as when we talk to service providers, and there is a project underway to create sort of standard terms and standard procedures for when we have to conclude data protection clauses, as they are sometimes called, and so again in the interim, sending these requests to the POPI email address is the appropriate way to go. Okay, I just want to remind my team members that they are more than happy. I'm more than happy for them to interrupt me when they want to add something. So please just chip in when the spirit moves you. Okay. Then there was a request for a POPI manual on how we handle research data. So certainly the ASAF code will I think evolve to become something of a POPI compliance manual or a manual for the handling of research data. We will be, as part of the POPI program, be creating manuals for the handling of personal information in general. But I imagine that will also then result in specific instructions when it comes to the handling of research data. Lynn, I don't know if you want to add something at this stage. Okay. You're on mute still. It's our theme for the day. Still on mute. Okay.
And now?
Now I can hear you, Lynn.
I think we're still all waiting with a bit of bated breath for the ASAF code. And in fact, there's just been an email this morning to say that they're planning to get the draft code out by the 1st of July, and that it will either be published by ASAF or by the information regulator. And I think there will be a period open for comment on that code. And then the information regulator will take, I think, up to 12 or 13 weeks. She has to approve the code, and then we'll have to see what's in it. It will be binding on researchers, but hopefully it will make a lot of things a lot clearer in terms of actually unpacking, what is research in the public interest, and some of those things. Hopefully in the code. There was a lot of response, ASAF has said, and so they are going to try and respond to all comments on concerns. One issue has been that that ethics committees are going to, in the code, are probably going to be used as quite a significant safeguard for POPI, and we're going to have to see exactly what implications that will have. But until we actually see a draft code, we can't really comment on that. I think, thanks.
Yeah, no, thank you, Lynn. I think that took care of quite a few of the research-related questions. And I want to echo what I imagine to be the frustration that researchers are feeling at the moment. It's very much a hurry up and wait scenario. So again, in the interim, when something happens that you don't feel comfortable with, or where you have specific concerns around the research activity, I want to urge everybody to reach out to this team, and we will advise you as best we can in the interim. What I can say from my perspective, so I'm not on the drafting team for the ASAF code, but have had many conversations with them, is that they do appear to be following international best practices, in largely gleaned from how the General Data Protection Regulation was implemented by universities in the European Union and then also in the United Kingdom. So for those of you who do want to start thinking about this topic, as I always find it useful to benchmark against our EU counterparts and our United Kingdom counterparts. The UK GDPR, as it is now known, is still the same as on the mainland. And the code, we don't expect that there's going to be anything in the code that is out of line with the initiatives that were taken during the rollout of the General Data Protection Regulation. And that helps me. Often when I feel POPI panic setting in, is that this is not new. It is very, very closely aligned with the General Data Protection Regulation in most respects. Lynn, you agree, I think? Yeah. So if you are uncertain, if you feel like you need immediate assistance with something, but please do reach out to us. Then there is another general question that was submitted in advance, and then I think we can move to today's the questions in the chat. But so what are the plans, or what plans are in place to ensure alignment with POPI and the GDPR? Furthermore, in light of the new POPI requirements and practices that will shortly come into effect, what accommodations are already in place for the GDPR? So at the moment, what we are doing is we are ensuring that UCT's policy framework reflects all of the principles that it needs to, both in terms of POPI and the GDPR. So this is a dual project, if you will, to ensure that if we're going to become POPI compliant, we might as well ensure that we can also demonstrate compliance to our European counterparts. What happens after that is a process of assessment. So just like with the GDPR, how you bring processes and research projects and other processing activities into line with the legislation is through doing something that is in South Africa referred to as a personal information impact assessment. We will be rolling out assessments on the main processing activities of the university, and then the rest will be assessed over time. And that is the continual work of becoming and remaining POPI and GDPR compliant, is to do these assessments. So I urge you also to ask for assessments if you are about to do something new, or the university is about to invest significant time or resources or funds in a new technology, or if there's something new that we are going to be doing with personal information, because we certainly don't want to introduce more risk in this sort of interim period. So do again reach out. If you see something, say something, I think is the slogan at this point, so that we ensure that we don't introduce new risks. Those personal information impact assessments, then what is produced by the assessment is a set of recommendations, and there are certain recommendations that are fairly universal. It's either changing the collection mechanism slightly, so that would be changes to forms, so where we stop over collecting, for instance. There might be changes from an information security management perspective or recommendations relating to that. Often we need to be transparent, so there might be recommendations relating to introducing a privacy notice or two, and often there are training requirements that are highlighted by these assessments. And so roughly about half of the effort going into a privacy program usually is expended on training, because a lot of this, as we said earlier, is behavioral. Okay, then how will the sharing of personal information with third parties, and the example mentioned here is recruitment agents, be handled? So third-party management is very important. We identify those instances where either information is shared with us or we are sharing information with third parties. And again, the context will determine a lot of the principles or the rules that will be in place around the sharing. So first off, we have to answer the question, are we allowed to share the information? Usually the answer is yes. Are we only sharing the information that we absolutely need to? Usually the answer to that is no, actually we were oversharing. So then we pare back the sharing. And then the last but very important question or category of questions that we have to ask of sharing activities is, are we sharing the information in the most secure way possible? A lot of data breaches are caused when information is in transit. It is inherently, very unsafe while it is in transit. So we need to also look at our mechanisms for sharing information. And then lastly, we need to make sure that all of these things are included in the appropriate contracts. And as I mentioned, there's already a project underway around managing all of these third parties with whom we share information, and putting the correct assessments and contracts in place. Will applicants be required to sign any kind of declaration at the point of application or registration related to POPI which grants permission for the university to use or share their personal information for admission purposes? So the good news is we don't need permission to use personal information for the admission purposes. That the justification that we'll be using is that the processing is necessary for the potential conclusion of a contract. What we will introduce into the application process is a student applicant privacy notice. So what we do have to do is we have to be transparent about what their information will be used for. So the application process is the first process that has been earmarked for assessment, in no small part because the university is in any event currently busy with a project that looks at the application process. And so we will be making recommendations about the notices that need to be introduced during that process. But it's not because we need consent to do anything that we are doing. It is because there are transparency requirements, but we are within our rights to process personal information for application purposes due to another legal justification, not consent. Okay. Then there was a question around whether we must add unsubscribes to the bottom of all of our emails, and the answer to that is no. People do not have a universal right to unsubscribe from receiving email. I would imagine a great deal of the traffic for internal email, for instance, at UCT, is these are emails that are necessary to enable people to do their jobs, and they don't have a right to unsubscribe from that. The right to unsubscribe from email applies to direct marketing. And in some instances, that will include emails aimed at soliciting donations. So usually the conversation around which emails to add unsubscribes to is something that is driven by the alumni office, because that is where a lot of the sort of more direct marketing type emails are going out from. But certainly generally, we do not need to add an unsubscribe to email, particularly when it is internal mail. Okay, then does the POPI Act require us to delete information on our department web pages? So POPI will prescribe what kind of information we should make public on the web pages, and I think it does mean that webmasters must be better at keeping those pages up to date. We've seen that some organizations have overreacted and taken all contact details off their pages. So the answer to that question will be dependent on what the role is of that staff member, and whether it is necessary for their information to be publicly available, because that does open them up to a certain level of risk. So again, the question is it absolutely necessary to publish that information on a public forum? or is there some other mechanism that we can use to make those contact details available? But certainly sometimes it will be appropriate. But what POPI will, and we see this very often, will force universities to do is to get a little bit more disciplined about how they keep their web pages up to date. There was a data breach, I think it's now 2 or 3 years ago at Greenwich University that illustrated this nicely. There was a web page created for a conference where people who wanted to come to the conference could submit their details, but also papers, and that that website was allowed to remain active well after the conference took place. And someone uploaded malicious code using the upload function, and that caused a significant breach. And if my memory serves me correctly, Greenwich got fined a couple of £100,000. And so what that illustrated was we do need to look at points of ingress that's created by our web pages and make sure that those web pages are up to date. But so the question to whether you are allowed to list someone's contact details it depends on that person's role at the university. If we can find a justification for listing it, we can. That's almost always going to be the answer. Okay, we supply specific information relating to UCT's inventors and external inventors to patent attorneys for recordal at the international patent offices. This can include nature of work, full names, nationality, and personal addresses. We also provide very detailed information to the Department of Higher Education to claim Creative and Innovation Input Awards, like publication count. Do you need to keep track of and obtain consents for this data from the data subject? To answer, it's a compound question, so I'm going to unpack it a bit. Do you need to keep track of it? Yes. So the university is under an obligation to keep a record of all processing and sharing of information. Do you need their permission? Probably not. A lot of the information that is required by the Department of Higher Education and required by attorneys who registered patents is determined by legislation or regulation. So as long as we're only sharing the information necessary to register the patent or the information necessary for the Department of Higher Education to perform whatever function it is that they're performing, we should be fine because we have legal justification to share the information. So we don't need permission because there's legislation or regulations or a public law duty that allows us to share that information. We do need to be transparent about it though. So we do need inventors to understand how their personal information is being used and shared. And we do need to keep a record of it. Okay, let's see on the Q&A. Okay. Will UCT be drafting a disclaimer which can be used by various departments when needing to collect personal information, or will every department have to draft their own disclaimer? Okay, so I think that the disclaimer that you're referring to is probably a privacy notice. A privacy notice is a document, usually it relates to a category of the data subjects like students, let's say registered students. What we are in the process of creating are privacy notices for these big categories that we are aware of. Similarly, as I understand it, the ASAF code will include a template of privacy notices for research projects. And so the departments will be able to take those privacy notices and in 9 times out of 10 just refer to the privacy notice itself. In some instances you may need to add something, or you may want to ask us or the POPI team at UCT to add something to the central privacy notices. But my experience has been at universities 9 times out of 10, the departments will just link to the applicable privacy notice. I think one of my team, well, what we will do actually in the frequently asked questions is to share some examples with you so you can start seeing what that looks like. But we are already in the process of developing privacy notices for UCT for use, so you will not have to draft your own. Okay, then for COVID compliance, we currently have to ask students to sign attendance registers. These include the students' names, phone numbers, signatures, and student numbers. Is this not a violation of POPI? I am concerned that students are able to see each other's phone numbers when some might want to keep this information private. So it seems just from the outset to me, not understanding exactly why you are asking for the cell phone numbers. There might be a valid reason, I can't exclude that, but for the most part, I would not think that collecting their contact details is necessary in that registry. So you are already applying, and congratulations, the less is more principle. So is there any way, how might we take attendance for purposes of COVID compliance, without asking for all of this information. What is the minimum amount of information that we can ask for? If we ask for information, but we can't justify why we need it to, then that will be an infringement of the Act. But as long as we've got an operational or legal reason why we are asking for those contact details, we will be fine. So the name of the game is always just asking why are we asking for these contact details in this particular context. A lot of organizations have interpreted disaster management regulations not necessarily to mean that they have to collect contact details in this way, but maybe UCT, I don't know, Registrar, if you want to talk to this specifically, but the question is going to be, why do we collect that information?
Yeah, I mean, thanks, Elizabeth. I do think that, I mean, there are a number of questions that have come up that you've responded to very well. It's very useful. There are a number of others that have come up that I think does need further thought. We don't certainly have the time to go through all of them now, and that's exactly what has been agreed in terms of what's come through in the Q&A. We are given an undertaking that we will respond to those and use the development of the Q&A as a tool that, as I'd indicated early on, will be a living tool, and it will be used for all of us to help to get to a point where we better understand what our obligations are. And we refine that understanding, and then we build systems, but also ways of working that take this into account. I agree absolutely that a really important and quite simple test initially is to always ask the question, do we really need this information for the purposes of the business that we are transacting? And if we can't figure out a really good, cogent, sensible reason as to why we are collecting certain bits of information, that already is a very good indication that maybe we don't need it. And if we don't need it, we can maybe reduce some of the burdens that we have. But if the answer to the question is yes, we do need that information, then of course we need to think about how we collect it, how we keep it safe, and how we make sure that it doesn't get, into the wrong hands. So that if we are audited on this, we actually have a good chance of being able to stand up to an audit test. I'm glad you made mention of the privacy notices in response to the question about whether there should be UCT disclaimers that are used by departments. I also want to make the point that, because I think there were 2 or 3 questions that had come in about when staff members use devices that are not UCT issued, and the implications of that in terms of our obligation for, POPIA compliance. The point is that the requirements and the obligations that we have in terms of POPIA are not diluted just because a staff member uses a device that is not a UCT issued device. It's completely separate matter. It's about still using the information and safeguarding the information that we have access to, quite independently of what that particular device might be. There was also a question around a generic set of POPIA rules to be adhered to by all organizations. I mean, I think in our particular context, it's the higher education sector that is most relevant, and we already have the USAF sector guidelines, to which as a university we subscribe, and that is available and has already been available. A further question around would each section be required at the university, each section at the university, to set up a task team. We actually don't think that is the case. We are trying to do this through a central project, but of course we are going to be drawing in more and more people to help us play a role, but we don't necessarily believe it is going to be a requirement that we set up, multitudes of different task teams. But I do think that leads as a nice segue into a really important point around this actually is also quite a big exercise in a culture change. A culture change in terms of how we work. And that I think is going to be an important part of this process. And so where we are also going to be leaning heavily on colleagues in departments, for the professional departments, as well as in the faculties, is that how we collectively, in a stepped way, but it will get to a point where it will have to compound, get to a point where we also are tackling the issue of this culture change and how we have to, number one, realize we need to work differently because of the obligations we have in terms of the legislation, and how we actually need to embrace ways of doing things that may be quite different to what we've been accustomed to for quite a long time. What I would like to suggest, given that it's 1:30 now, and we don't obviously want to go beyond that, I think this has been a very useful session. It is part of a process of advocacy, of having information sessions to build increasing understanding and awareness. We will certainly add this to the Q&A tool, and we will make that available. It is very likely that we will have subsequent and follow-up information sessions like the one that we are having now, and I've already made the point about the culture change requirement. So our request and appeal to our colleagues is to keep those questions coming in, because that's actually how we will contribute and add to our capacity to get to a point where this journey that we're on is a useful one, and it will put us in a position where we can withstand some of the tests. That will come, there's no doubt that it will. It will come in terms of how, as an organization, we deal with respecting what needs to be respected in terms of information privacy. I'd like to suggest then at that point we bring the session to a close. I'd like to thank you, Elizabeth, certainly for that very, very useful and comprehensive presentation. We again also thank the colleagues who've come back into the meeting. I mean, we were at 400 at one stage. We're at 320 now. I think it's a very good attendance rate. So appreciate the time, the fact that you've made the time and put in the effort. And at that point, and also obviously there are other colleagues from Novation in the meeting who are also assisting us, and of course our own colleagues from UCT on the technical side, the DAD side, the research side, and the ICTS side, and a number of others. I certainly don't want to mention anybody by name. That won't be appropriate. But a number of people are actually making a contribution to do what we need to do as a public university in terms of what the legislation requires. So I'd like to bring it to a closure at that particular point and thank everybody for your attendance and for your interest. Thank you very much.
Thank you.
Cheerio. Bye-bye.